Hi, everybody. Welcome back to the 10th of an Hour with Griffin Bridgers. For today's episode, episode 123, I'm going to kind of take a step back from a more technical discussion, and I'm going to go more grassroots into the basics of powers of appointment. I reference powers of appointment in a lot of my discussions just because they're very significant for tax and property law purposes and really relate to estate planning. But a lot of people don't really fully understand what powers of appointment might be. There's a lot of nuances that I can cover in a series of discussions, and really for today, my goal is just to kind of get some of the basics down on paper so that you can see or understand better what a power of appointment is and how it might be classified. Now, as always, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. So, powers of appointment are just simply the power to take property that's owned by another person and transfer it. Now, where this most often applies is in trust, because in most property ownership situations, the person who owns the property has the exclusive right to transfer that property. Now, that right to transfer is known as alienation in legal speak. But in situations, especially like trusts, where ownership and benefit can be split, it makes more sense to kind of give other people the right possibly to transfer the property owned by the trustee. So, powers of appointment can help create flexibility within trusts themselves. So, powers of appointment are generally defined a little bit differently when you compare property law to tax law, and we'll dive into those differences in greater detail in a later discussion, but even without getting into the classification of powers of appointment, I think it's important to point out that property law generally excludes any powers that are subject to a fiduciary duty from the definition of powers of appointment, whereas tax law doesn't care whether there's a fiduciary duty. Tax law will just include both fiduciary and non-fiduciary powers in the definition of a power of appointment. So like I said, that's a discussion for another time, but when it comes to the creation of a power of appointment, there's typically three parties involved. One is the donor, that's the person who creates the power of appointment. The other is the holder, that's the person who can exercise the power of appointment. And then the third party is known as a donee, or sometimes an appointee, and that's the person who can benefit from the holder's exercise of that power of appointment. Now, all three parties could be the same person, and two of the three could be the same person as well. So you could have donor as the holder, or holder as the donee, or even donor as donee, whatever the case might be. And these combinations of parties typically will determine the classification of the power of appointment for property law and tax law purposes. Now, one parallel I want to point out here is, much like there's three parties to a power of appointment, there's also three parties to a trust. There's typically the grantor of the trust who creates it. There's the trustee of the trust who owns the trust property and can distribute it out. And then there's beneficiaries who could benefit from the trustee's exercise of their distribution power. Now, if you see an exact perfect parallel in my description of those three parties, that's not coincidental. This is really kind of a way to mirror the effects of a trust, and the only real difference here is that while a trustee has a fiduciary duty, the holder of a power of appointment might not, as I just mentioned on the last slide. So the three parties to a trust largely mirror the three parties to a power of appointment. Now, when it comes to the classification of powers of appointment, typically they're going to fall into two categories: general and non-general powers of appointment. Now, what really matters here is knowing what a general power of appointment is. That's typically a power where the holder can personally benefit from that power of appointment. So the holder and the donee are the same person, and there are no strings attached that would limit the holder's ability to personally benefit from that power of appointment. So strings that would keep a power from being a general power of appointment, even if the holder and the donee are the same person, would be: one, if the holder is limited to an ascertainable standard. So in other words, if the holder can only use the power to give themselves assets to the extent of their health, education, maintenance, and support, that would not be a general power of appointment. Another limitation that keeps a power from being a general power of appointment is if the holder has to get the consent of an adverse party first before exercising that power of appointment. So an adverse party would be somebody like another donee of the power of appointment or a beneficiary of the trust, but they're adverse because that donee or beneficiary would be hurt by the donor's exercise of that power of appointment. Now, non-general powers of appointment are simply powers that are not general powers of appointment. And non-general powers of appointment are also known as special or limited powers of appointment. And these are just powers where the holder and donee are not the same person, or if they are the same person, there are sufficient strings attached, as we discussed above, to keep the power from being a general power of appointment. So if you had a holder as the donee, but they had to limit their distributions personally to an ascertainable standard or get the consent of an adverse party, that would be a limited or special or non-general power of appointment, whatever nomenclature you want to use to describe it. Now, timing of the powers of appointment can also create subclassifications of general and non-general powers of appointment. So lifetime powers of appointment are ones that can be exercised by the holder during their lifetime, whereas testamentary powers of appointment are ones that can only be exercised by the holder at their death, typically through a testamentary instrument like a will or a revocable trust. Now, a holder could be granted both a lifetime and testamentary power of appointment over the same property, but they're typically treated separately, even though they might be combined in the same trust provision, and they typically have different methods of exercise as well, which makes sense. A will is not going to be effective during the holder's lifetime and couldn't be used to exercise a lifetime power of appointment, and vice versa. So the big question here is, why do we care about this? Why create powers of appointment? Well, the fact that transfers to a trust are usually final and irrevocable create a lot of inflexibility. A trustee is typically the only person who can distribute property out of a trust or maybe to a different trust, and the trustee has limited discretion to make those types of distributions, and typically that discretion would keep the trustee from making distributions in a way that might meaningfully change an otherwise irrevocable trust. And even if the trustee does have that power, the trustee has a fiduciary duty to all of the trust beneficiaries, and that might discourage the trustee from, say, cutting out a beneficiary or changing a beneficiary's stream of income from a trust, or whatever the case might be. So what powers of appointment do is they give somebody else on the outside, or maybe on the inside, the power to have flexibility to change the terms and beneficiaries of an otherwise irrevocable trust. Now, beyond that, powers of appointment could also be used to create certain tax and asset protection benefits for the trust beneficiaries. So within that, for example, the class of donees could be as broad or as narrow as the donor desires. And there could be an exclusive right where you have to benefit all those donees, or a non-exclusive where the holder could pick and choose which donees benefit from the power of appointment. And most powers can be exercised in a way that might give property directly to donees, or give them a beneficial interest maybe in a new trust, or even give the donees their own power of appointment. Now finally, it's important to note, as a prelude to our later discussions, that the classification, the timing, the exercise, the expiration, or even the mere existence of powers of appointment can create both good and bad outcomes from both a tax law and a property law perspective. And that's where a lot of the hand-wringing comes when we look at powers of appointment and how they're deployed within an estate plan. But like I said, that is a subject for another time. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. But thank you for listening to this episode of The 10th of an Hour, and I look forward to seeing you in the next one.